one of the things I do as an attorney is I represent other attorneys and judges, but usually just attorneys, who have been charged with violations of the rules for attorneys, the rules of professional conduct. And frequently they'll be subject to discipline for their misbehavior, but often they're going to be in a situation where their license is in jeopardy. And in New Jersey, we're kind of unique in the sense that once you lose your license to practice law in New Jersey, it's a lifetime loss of license. There's no way you can go like 5 years and reapply or something of that nature. It's basically something that's forever, which is, by the way, is unusual among the states. Many other states will let you reapply for a license in 5 years. I have a guy I just represented who stole $2 million or something like that. He was disbarred, of course, in New Jersey. He was also disbarred in Pennsylvania, but the Pennsylvania people are calling me on the phone saying, now remember, tell him he can reapply after 5 years to be a lawyer. I'm not sure I'll tell him after he gets out of prison. I wish I were exaggerating, but I'm not. So what I have found in my professional endeavors is that the accountant, especially certified public accountant, is the difference between whether or not my client generally is going to lose his license or not, okay? And my purpose today is to talk to you somewhat about some of the arcane accounting principles that apply to attorney trust accounts, not so much from an accounting standpoint, but from a legal standpoint. So when you get involved in one of these cases, you'll be able to approach it in terms of knowing what the background is, to be able to put everything in context. The materials I've given you should give you kind of a roadmap about what you should be looking for, what to anticipate, especially when there's going to be an audit, and to look for problem areas so that the attorney who's, your client can have him and his staff corrected in terms of their practices. Now, the starting point for the analysis is the New Jersey Constitution of 1947. We've actually had 3 constitutions in our state: 1776, 1844, and the most recent, the one we've lived under since 1947. Article 6, Section 1 creates the judiciary, and there's 2 sections here which will be of note for you. Judicial power shall be vested in the Supreme Court, Superior Court, and other courts of limited jurisdiction. Those would be the tax court and New Jersey municipal courts, or the courts of lower jurisdiction. Other courts in their jurisdiction may from time to time be established, abolished, or altered. Now here's the key part for you. The Supreme Court shall make rules governing the administration of all courts in the state, and subject to the law, the practice and procedure of all such courts. The Supreme Court shall have jurisdiction over the admission to practice of law and the discipline of persons admitted. So the power of the Supreme Court to do all this is set forth right there in Section 2. Everything comes back to that. Now, this has manifested itself from our perspective today in 3 general areas. First, the adoption of a rule, and it's Rule 1:21-6, which has all the accounting principles that the attorneys have to comply with. One of the rules of professional conduct, RPC 1:15, which we'll talk about also, is an accounting type rule. And finally, you'll see a number of published decisions by the New Jersey Supreme Court which serve as precedent for how attorneys are going to be treated in our state when there's accounting violations. All right? Now, just a little bit about the characteristics of the New Jersey bar in particular, for marketing purposes for everybody, I guess. There are, as of December of last year, 85,089 attorneys admitted to practice in our state. New Jersey is 8th in the United States in numbers of attorneys. The ones who are engaged in private practice, 34,381, that's 40%, and 90% of those practice in the state of New Jersey. I would imagine the remaining 50,000 are all in government teaching and things of that nature, but primarily government. Full-time, 21,000, part-time, 73, and these are the people who are just occasionally, like my wife, occasionally involved, like once a year, and undefined. That's also my wife. All right. Law firm structure. This doesn't add up to the 34,000 because not everybody filled out the survey they sent out. Survey said 11,068 are sole practitioners, and there are 3,439 two-person firms. I don't know how the arithmetic comes out on this, where you get 1,720 firms with that number, but that's okay. 5,245 for 3 to 5, 6 to 49, and 50 or more. Now, what I'm telling you is where you're going to see your clients coming from who are going to have problems are going to be in these 2 areas, primarily in sole practitioners, occasionally on the two-person firms. When you start to get into the 3 to 5 attorney firms, generally they're going to have the time, staff, training to undertake their professional accounting responsibilities properly and do it within conformity with the rules of court. The smaller firms, though, especially the sole practitioners, where you're going to run into cash flow problems, poor management, very poor or no oversight, undercapitalized, personnel problems, whatever it may be, this is where you're likely going to get involved, especially if you're going to be involved in something with forensic accounting. Okay? Now, as I just indicated, the vast majority of accounting issues arise in the context of sole practitioners or small firms for the reasons we just talked about. The Office of Attorney Ethics, which is the general administrative body that kind of oversees all this, keeps statistics on the main types of complaints that come before them. Gross neglect or pattern of neglect is the number one reason that there's complaints filed against attorneys. 28% of all the complaints are for that. The next two are the ones that are going to be concerned for you. Negligent or reckless misappropriation of entrusted funds, 20%, and knowing misappropriation of entrusted funds is 16%. So you're seeing here 37% plus of the complaints, more than a third, are going to be money-related, accounting-related type problems. Now, the key thing, we'll get into this right now, you've got to think about this as a theme that's going through here, is this. That for a knowing misappropriation of entrusted funds, there's an automatic disbarment rule in New Jersey called the Wilson Rule, all right? And if there's a finding that an attorney has knowingly misappropriated entrusted funds, finding made by clear and convincing evidence, disbarment is automatic. There's nothing you can do to save the attorney under those circumstances. By the same token, if the misappropriation was due to recklessness or negligence, it's not a knowing misappropriation, and as a result, although there will likely be some form of discipline, it could be in the form of a reprimand or a temporary suspension from practice or something like that, it's not the type of case that's appropriate for a disbarment, all right? And the person who makes the difference in these types of cases is all of you. Okay. In the latest report, I was kind of concerned about how much money is actually being held. Just in normal trust accounts in New Jersey is $3 billion on deposit. Additional sums, unknown amount, but I'm sure more than $3 billion, are held by attorneys all over the state for estates and guardianships and things of that nature, other types of trust activities. But the normal attorney trust accounts total $3 billion, a lot of money to keep track of. All right. Now, there's two things that the state has done administratively to try to enforce the accounting regulations for attorneys. And the first one is the Random Audit Compliance Program. And basically what they do is they have a program that they utilize that will select attorneys at random. It's all done by computer, so it is truly a random selection process. And the purpose of it is basically to spot problems that before they become something that would be very serious. Now, normally it's going to be something very minor. You might have the wrong name on a checking account, or not reconciling books often enough, or something of that nature. They normally find something. But what they're looking for are misappropriations of entrusted funds, especially those that can be attributable to knowing conduct by the attorney in question.